everyone, it's Camille from Unbridely. Today I am chatting about something that's a little bit different from weddings, but something that I can guarantee is going to apply to you. Just over 50% of adults in Australia don't have a will, but 100% of us are gonna die. So it's, yeah. So Brooke, you laugh, but that's the truth.
It's a fact.
So Brooke Reardon is here from Wills and Estates, and Brooke is an amazing lawyer who takes care of specifically looking after people's wills.
When I first started my business, I was in general practice, and people kept coming up to me and saying, "Oh, do you do wills?" You know, whether I was at a party and they'd find out what I did, or a kid's birthday party.
Oh, it's like a doctor. Can you just check this?
Exactly.
Nice.
I've got this pain. Yeah. I'm like, why? Where is this coming from? Why don't people have their wills done? So I set up the business to try and counteract that and change how we are currently in society around wills.
I want to ask, and I want everyone to know, why do we make wills?
Right. So the will essentially is a document that you create to tell people what you want to happen to everything that's left behind of yours once you're gone. So once you do that will, and there's obviously requirements to make a will valid, we've got to take it through the court once you're deceased. We go to the court and we say, this is so-and-so's will. Can we administer their estate, please? And if the court is happy with how the will's been drawn and that it's all correct and legally valid and binding, they'll essentially rubber stamp it, say, yes, you can now go and deal with that estate in accordance with that will. So it's essentially allowing whoever you appoint in the will as an executor, which is the term for the person who essentially takes charge of making sure everything happens in accordance with your will at the end of the day, can go and do that. I feel it achieves the continuation of your legacy. That's what I see it as expressing personally, is who you want to look after your children if you were gone, both you and your husband or partner were gone.
Right, so that can be written in as well. It's not just worldly possessions.
Yeah.
But wow, okay.
Guardianship clauses. You can also put in there what you want to happen to your pets. I think pet ownership here in Australia, we're one of the highest numbers worldwide for pet ownership. That's something that I see more and more, is people considering, how are the pets going to be looked after? Who do I want to look after them? And how are they going to fund that? And what happens if someone isn't there to take them? Well, how do I want them cared for? Do I want them just going to anyone? Or, you know, do I want them euthanized? Your worldly possessions, as far as your estate, there's a lot of things that you can do in your will to actually make it financially better for your loved ones, potentially, depending on what structures you put in your will. If you pass away intestate without a will, the law just has a very basic tree as to how things are divided amongst.
That's what I'd love to ask, Brooke. Like, what happens if you don't have a will? Like, what's the default?
Yeah, so the default is different in every state. So I'll start with that. Depending on where the majority of your assets are held is generally the state that the lawyer will seek letters of administration in. So you have two processes. Probate is for when you have a will and you need to get that stamp on it. When you die intestate without a will, you need to go, or whoever's left behind to wrap up your estate has to go get what's called letters of administration. So they need to get permission from the court to go and administer your estate. And the default position in each state is different. Generally, the provisions will be something along the lines of, if you're partnered, it'll go directly all to your partner if that reaches the de facto status. So if you've been together long enough. Here in South Australia, it's 3 years in that area of law. Victoria's 2 years. If you have a child with your partner, then in some states they leave a certain amount, like a dollar figure amount, to the partner, and then the remainder to the children, in depending how many divided. So that's held on trust for the children.
Do I really need a will?
Absolutely. So the first question that I would pose to a client in that type of circumstance where they said, oh, but I don't have that much in assets, is generally once you hit 18 and you enter the workforce, or if you've entered beforehand, you'll have super. And generally with your super, once you start contributing to that, you'll have life insurance attached to that. Because that's held in a trust, it's held in super, it's not yours, it's the trust as such that owns that, which means that you can't say necessarily where you want it to go in your will alone. You need to have what's called a binding death benefit nomination. And you get those from the super company, they're free, and then you fill it in. What makes it binding normally is that you have two people over the age of 18 independent to you witness what you write on that. So they sign it to say, yep, I saw Camille say she wants that all to go to Brooke, and they sign it. And then you send it back to the super company, they lodge it on their records, and it tells that trust, the super company, where to send all of that money in the event of your death. Right. So that's one thing that I would say.
Everyone should be jumping on that now.
Yeah.
You got to do that now. Okay.
Don't do it now. There's the barriers are low to it. You can usually just print it off at home. Wills aren't cookie cutters. You're not a cookie. You're not. Your situation is unique.
No, I'm not.
You're not a cookie. So your will needs to reflect that, and it does need to take into account that if you want it to go to someone in particular, it should reflect it.
You know, when like I sit down as a celebrant, I have to hand couples this gorgeous little flyer.
Riveting.
These it's great, and it says making a will. Marriage will invalidate any previous wills unless your will clearly shows you are planning marriage.
I love this. So I hear this quite frequently, is that, yeah, but if I get married, it just gets invalidated anyway. So why don't I just wait until I'm married? Yeah. And there is a clause that we can write in there as lawyers to say that the will has been made in contemplation of marriage. Particularly now with COVID and the delays that have been happening, I would strongly recommend people go and get the will done. Don't wait until you're married. I remember reading a story about a lady in Western Australia who was newly married, didn't have a will. The house was in the husband's name only. She was newly married, newly pregnant. He died unexpectedly. Wow. And the bank refused to talk to her, couldn't access anything. They sold the house, recovered their money essentially, and she was out. It's a highly traumatic thing to go through anyway, but people need to realize that the bodies that you need to deal with, whether it's insurance companies, banks, it's not as easy as what you think it's going to be. It's not always just a phone call to say, so-and-so has passed away, can you help? It can be an overload of administration that comes through. It can sometimes just be, we can't talk to you. Do you have a will that has appointed you executor? You know, has that gone through probate? Do you have letters of administration? Because otherwise we won't be able to talk to you and help you with that. So sometimes there can be real barriers for people. And I'm not saying that's right or correct, but it's very stressful time, and it can be made a lot easier if you have a will in place.
Let's say it's one of my couples, they're having a great time, they plan their wedding, they get married, and off they go into the sunset. If they don't have a will, won't everything just end up with the other spouse anyway? I guess a lot of people think that the default is going to be fine.
Yeah. So if they're married and they die intestate, so without a will, then depending on what the law says in each of the jurisdictions, it potentially goes straight to the spouse with a potential split to the children if there are any as well.
Right.
Anything that's held in joint names is automatically owned by the other person upon death anyway.
Okay.
So you can't give away things that are held in joint names anyway.
Yeah.
The aspect that I would potentially be concerned about is the protection for any future children. So, or if there are children, if the amount goes straight into the spouse's name, how do you ensure that if they remarry, that amount that you'd left for your children is protected just for those children, and not potentially blended family sharing or new children that are added into the family somehow, or you know, potentially left for the new spouse in some way? How do you ensure that happens on both sides? Because I understand, you know, we would all say, oh, well, of course I'd give our children my money if I was to pass away, but things can change.
It gets a bit murky, doesn't it? And so are these sort of circumstances, like potential scenarios, things that you're walking people through when they're doing their wills.
Absolutely, yes. So when people come in to see us, so we do our first 2 appointments free, because we're all about removing barriers, and knowledge is one of them, price is the other one, and we want people to know about that type of thing. So before they make a decision, first appointment, we talk to them about their unique situation. So we get all the details down about who they are, who's involved in their situation, how they think they might want things split, anything that's gone before, anything that's coming after potentially, so that we have an idea of their assets. The next appointment that we have is with the lawyer, and at that appointment we go back over all of that information to make sure that we have a full understanding of it, and then give you advice as to what we believe would be the best documents for your situation, and what they would include in them to reflect your circumstances and your wishes and how you'd want your legacy left. Most people will come to us and they'll say, and this is common across all lawyers in this area, I just need a simple will.
Yes.
That's all I need.
Yes.
And we are not McDonald's. We are not trying to upsell you.
Perhaps you could explain that, Brooke, like the difference between the process that you were just talking about of having the 2 free consultations and sitting down and working through the potential scenarios, and the one that you get from the post office.
So the post office wills, I don't have anything against them, except that people frequently buy them and put them in the bottom drawer and think that they'll fill them in later on. I think Peter Brock had 3 different post office wills all at once, and one was filled in with 2 different coloured pens. They can go wrong. It's very much open for user error frequently. And a barrister that I know once said to me, when they're asked about, why would I go get someone to go do a will when I can get it from the post office? And they said, well, look, yeah, go get it from the post office, because I'll make more money that way when you've done that, because they're more likely to be contested and more likely to be wrong and need direction from the court as to how it's to be interpreted. Then just a simple will, which is generally, and look, we have a simple will on our website for people to use, which is a will kit, part of a will kit. You can jump on, enter your information. We have a screening questionnaire beforehand to make sure it is actually suitable for you. And it literally will say, I leave everything to my other person, whoever that might be, and then if they pass away, then I leave it to these other people. You generally won't see guardianship clauses in them. You generally won't see complex testamentary trusts in there. There's lots of different aspects that a simple will doesn't cater for, that in some circumstances might be necessary, particularly like where you have small businesses and things like that as well. The will deals with when you're deceased. It says who's in charge of all your stuff and dealing with, and tells them where it goes. It's for when you're deceased. But then there's other documents for when you're alive but incapacitated. So if you, for whatever reason, were unable to make decisions on your own behalf, which does happen, unfortunately, then someone else could do that for you. So here in South Australia, the Advanced Health Directive will deal with all your medical decisions. It'll tell the hospital who will make those decisions on your behalf when you're unable to. You can also put in there how you want to be cared for, essentially.
Yeah.
At that point in time as well. So it's quite a complex document, but it's definitely there, and we do those all the time. The second one is it's a power of attorney document, and we normally recommend the enduring power of attorney, and that's for personal financial decisions. So someone can go and deal with the bank or use your money for purposes for you or your children if they needed to. While you were still alive. Those documents are very important as well to have in place, and particularly if you're running a small business, what's your succession plan or your capacity plan or incapacity plan. When clients come in to us, we will definitely talk about their wills, but we always talk about power of attorney, and I say power of attorney to encompass both of those documents that we were talking about. There's something different in every state as well. That's also state-based legislation. So, if you move to Queensland or wherever, then you would need to reassess those documents to make sure that they were still aligned with what your wishes were at that point in time.
You're based in South Australia here, Brooke, so you're all across the South Australian legislation. But what if like people came to you from other states, are you able to help them?
I'm based in South Australia. I have a Victorian practicing certificate. I am originally from Queensland though, so I did my law degree in Queensland, and I actually did my articled clerkship and was originally admitted up there. We are national. We have lawyers currently in Queensland, New South Wales, Victoria, South Australia. Other than myself, we have a South Australian lawyer. So we are able to assist people in all of those states currently.
And you guys do the first 2 consultations for free.
For free.
Roughly, like, because when I chatted with some other friends about why they hadn't done their wills, a lot of them just said it's overwhelming. It's just overwhelming, and they just keep pushing it back. So I was wondering if you could tell people, like, roughly from start to finish, how long does it take to make a will?
So we have the first appointment might be an hour, and then we try to book it for the same time the following week, because we've all got a lot going on and it's just easier if we keep it at a set schedule. So you come back in and you have your appointment with the lawyer, which is an hour. And when I say come back in, we actually are a remote operating firm, so we do everything online like this.
Oh my God, that's awesome.
I love it.
That's another barrier, right?
Absolutely. It's all about removing those barriers for people. So that way, if there were 2 people that wanted to attend the appointment together to get information together, we can do that, and they can be in separate offices, on their lunch breaks or whatever. And then maybe an hour for just running back through the drafts and signing off on the documents.
Is there like a price range you could give us, like, roughly?
Because we're all about removing barriers, we've made our fees fixed, so it doesn't matter how many assets you've got, who you are, how complex the situation is. We, depending on what the type of will is, we'll tell you what that is at the second appointment. We'll tell you, look, these are the documents we recommend. A simple will with us, we've got our will kit online, which is $110 for you to jump on. That's still checked by a lawyer, so you type in your information, we'll still jump on and make sure that you haven't spelt Barry when it was meant to be Bernard or something.
Sure.
To make sure it's all going to be no issues when you go through that probate process. To $1,900 for a testamentary trust couple pack with power of attorney documents and things like that. The big thing that I'd like people to remember when they're looking at wills and prioritizing it and budgets and things like that is that think about what it's dealing with, lasting your whole legacy. It's encapsulating that for the people that you leave behind. One thing I'd really like people to do is just to do that first step, whether or not, and for me, the first step is booking an appointment. That first free appointment, get your advice. Once you've got that ball rolling, I think it helps remove a lot of the overwhelm. Have the conversation with the people around you and then do something. Like, that's the next part of it, is taking action on these things. We need to realize that not making a decision and not making a choice and not making a will is still a decision. We're choosing not to tell people what we want. We're choosing to not tell people who we would have chosen if we weren't here.
Thank you so much for spending some time with me today. I want to let everyone know where they can find you.
Oh, thank you so much for having me along today. I really appreciate the opportunity to talk to everyone about this, and they can find us. So we're on Facebook, Insta, we've got the webpage. It's all at Wills N for Nelly Estates. You'll be able to find us and follow us on there. We're constantly posting information on there. It's all about trying to increase the public's knowledge, and we've got a Mythbuster series out there. We've got a Will Blocker series. We've got the public stories as well. If anyone has a story that they would feel comfortable sharing in some way, you can remain anonymous. You don't have to disclose your name. Please contact us. We'd like to hear your story, and we'd like to, if you're comfortable, obviously share that and try and get a public conversation around this happening.
That's beautiful. So it's Wills and Estates,
yes,
as if you were like a rapper or something.
Is
that right?
Thank you so much, Camille. Bye.